Hello everyone, I am Anuj Nakade and you're watching Livelaw. In today's video, we bring you a very important update from the Supreme Court regarding Internet shutdowns. This is an update from the case of Anuradha Bhasin V Union of India. This judgment applies restrictions on the conditions under which the government can shut down internet services in the country or a specific area of the country. But before you bring you an update on Thursday's proceeding, here's the background of the issue. It all started on the 4th of August 2019 in the Kashmir Valley. On this date, mobile phone networks, internet services and even landline connectivity were all discontinued in the valley. There were some restrictions on movement in some parts of the valley as well. A day after that, on the 5th of August, the special status of Jammu and Kashmir was abrogated. Soon after, Section 144 of the Code of Criminal Procedure was imposed. Because of this, the movement of people was severely restricted and public gatherings were banned. This affected a lot of journalistic institutions such as newspapers. Because of the restrictions, their newspapers or even articles could not be published in any way. So Anuradha Bhasin, the executive editor of the Kashmir Times Daily and a member of the Rajya Sabha Ghulam Nabi Azan, challenged the restrictions on all modes of communication like mobile phone networks and the internet in the Supreme Court. They wanted all modes of communication to return to Jammu and Kashmir and to ensure free and safe movement of reporters and journalists along with all other media personnel. Important to this video, they also asked the Supreme Court to frame guidelines ensuring that the rights and means of media personnel to report and publish news is not restricted unnecessarily. A bench of Justice N.V. Ramana, Justice Surya Kant and Justice B.R. Gavai heard the matter. The court said that the freedom of speech and expression on the internet is an integral part of speech under Article 19(1)(a) and is only subject to restrictions on speech under Article 19(2) of the Constitution. The court also recognized that the internet is a very important tool for trade and commerce. The court said that the freedom of trade and commerce through the internet is also constitutionally protected under Article 19(1)(g) of the Constitution, which is subject to the restrictions under Article 19(6). So, the court very categorically said that indefinite shutdowns are not permissible under the Constitution. The court said in its conclusion, any order suspending internet under the suspension rules is subject to judicial review based on parameters set out herein. The court also said in its order that repetitive orders under Section 144 of the Code of Criminal Procedure would be an abuse of power. Specific to internet shutdowns, the court passed the following directions. An order suspending the internet services indefinitely is impermissible under the Temporary Suspension of Telecom Services, Public Emergency or Public Service Rules 2017. Suspension can be utilized for a temporary duration only. Any order suspending internet issued under the suspension rules must adhere to the principles of proportionality and must not extend beyond the necessary duration. Any order suspending the internet under the suspension rules is subject to judicial review. These guidelines were passed by the Supreme Court in the Anuradha Bhasin judgment in January of 2020. On Thursday, the 11th of May, the court heard an application that was filed in this case seeking compliance of the government with the guidelines of the Supreme Court in this judgment. A three-judge bench of Justice B.R. Gavai, Justice Sanjay Karol and Justice Arvind Kumar heard this matter. During the hearing, Advocate Vrinda Bhandari told the court that the applicants in this application have filed RTI applications seeking the status of compliance of the authorities. The authorities have responded saying that they are not aware of the judgment. Senior Advocate Nakul Diwan, while appearing for another applicant in the case, told the court that the Supreme Court has already sought the response of the Ministry of Communications on the protocol of internet shutdowns in an earlier similar application in September of 2022. Our fundamental right to speech and our access to information can shape our actions in real time and is directly related to our ability to access the internet. The court will hear this application again in 8 weeks, and we intend to bring you the updates in that proceeding. To stay updated, please subscribe to our channel and hit the bell icon for notifications. If you found this video informative, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Thank you.